Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we are dealing with unfortunate modern-day slavery and exploitation involving a mentally disabled child. All kinds of exciting. This is United States of America versus Bobby Paul Edwards. In this case, Mr. Edwards enslaved a mentally disabled child to work at his restaurant for 5 years. And the police caught him, and slavery is very, very illegal. So Mr. Edwards here has to go to jail, and then the question is, how much money does Mr. Edwards have to give the disabled child that he enslaved in his restaurant in Conway, South Carolina for a period of 5 years from 2009 to 2014? Let's get started with this. For over 5 years, from 2005 to 2014, Bobby Edwards, the manager of J&J Cafeteria in Conway, South Carolina, effectively enslaved JCS, to who we will refer with the fictitious name of Jack, forcing him to work at the restaurant over 100 hours per week without pay. So yeah, the manager of this cafeteria-style restaurant in Conway, South Carolina, for 5 years, decided to enslave Jack here. What did that comprise? Well, let's read some more. In 1990, when Jack was 12 years old, he started working part-time at J&J Cafeteria as a dishwasher. He has an intellectual disability and an IQ of approximately 70. After a few years of working part-time, Jack dropped out of high school and started working full-time at the restaurant. For the first 19 years of his employment, when the restaurant was owned and managed by different members of the Edwards family, Jack was paid well for his labor. So Jack here was working for this family-owned restaurant for 19 years. He has an intellectual disability, but he's gainfully employed. He's a dishwasher. He's been there for 19 years. Everyone's happy. And then suddenly Bobby over here decides to enter the picture. So that changed in September of 2009 after Bobby Edwards took over management of the restaurant. Not as gracious as the people who preceded him. Edwards moved Jack into an apartment attached to the restaurant and forced him to work 100 hours per week without pay. So I am holding you in the restaurant, essentially, against your will, and I'm making you work without paying you anything. He made him usually work from 6 a.m. to 11 p.m. 6 days a week, and 6 a.m. to 2 p.m. on Sundays. He got a little bit early off on Sundays. Not only did Jack work long hours without pay, he was never given a day off. Edwards effected this forced labor by taking advantage of Jack's intellectual disability and keeping Jack isolated from his family, threatening to have him arrested and verbally abusing him. His control over Jack also involved physical abuse. Once, when Jack failed to deliver fried chicken to the buffet as quickly as Edward had demanded, Edward dipped metal tongs into hot grease and pressed them to Jack's neck, resulting in burns that fellow employees had to immediately treat. Other times, when Jack made supposed mistakes, Edward whipped him with his belt, beat him with kitchen pans, and punched him with his fists. This treatment left Jack physically and psychologically scarred. Jack later said, "I felt like I was in prison. Most of the time I felt unsafe, like Bobby could kill me if he wanted. I wanted to get out of that place so bad, but I couldn't think about how I could without being hurt." So, yeah, this is going just as great as the title and intro basically suggested. So, the new manager of this restaurant, after 19 years of this guy being a faithful and loyal employee of this business, and apparently doing a good job for 19 years, the new manager of this business says, I'm going to reward this guy's hard work by enslaving him. I'm going to move him into an apartment that's attached to the restaurant. So effectively, I'm moving him into the restaurant. I make him work all the time. And if he doesn't cooperate, I beat him. And I scar him with metal tongs that were dipped into hot grease, and beat him with my belt. And I threaten him and coerce him to make him work in my restaurant. This is going over really, really great here. Just super, super great here at this restaurant in Conway, South Carolina. So let's read some more. Edward's reign of terror over Jack ended in 2014 when a relative of a restaurant employee alerted authorities to Edward's abuse, and the South Carolina Department of Social Services removed Jack from J&J cafeteria. So apparently someone thought, not all was right in the state of Denmark, and someone investigated, and yeah. And then Edwards finds out, slavery is illegal. Edward pleads guilty to one count of forced labor in violation of law, 18 U.S.C. 1589, and the district court sentenced him to 120 months imprisonment, which, if anything, sounds short. But, 10 years is better than nothing, sort of. In addition, the district court Edwards to pay Jack restitution in the amount of $272,952.96. The government requested an additional $272,952.96 in the form of liquidated damages as provided by law, but the district court rejected that request, reasoning that the liquidated damages are statutory punitive damages that are not available under restitution. So there is a law that makes slavery illegal, as you might expect, and the law against slavery, in addition to punishing the enslaver, also requires the enslaver to give back pay. And to calculate the back pay, you look at the federal minimum guaranteed minimum wage plus overtime, because this is a non-exempt employee, right? So, okay, how much for 5 years of employment for 100 hours a week at minimum wage plus overtime rate? How much is that? Well, as it turns out, the amount of money was $272,952.96. That's minimum wage rates. That's how much this guy was abused. He was cheated out of nearly $300,000 at minimum wage rates. Wow. And part of the statute also says that you might be able to give some damages as well. And the government says, we'd like those damages, please. And the court says no, because they're not available in a criminal case. Okay, so now we have to figure out whether or not he gets his $300,000 of back pay, or whether or not he gets a times 2 multiplier. Let's find out. The relevant federal law was passed to implement the 13th Amendment against slavery or involuntary servitude, and provides that a person who obtains forced labor shall be punished by a fine or imprisonment up to 20 years or both. Specifically, it punishes any person who knowingly provides or obtains the labor services or services of a person by, among other means, force, threats of force, physical restraint, or threats of physical restraint to that person or another person, or serious harm or threats of serious harm to that person or another person. In addition, the Act provides that the court shall order restitution, directing the defendant to pay the victim the full amount of the victim's losses, and defines full amounts of losses to mean the same meaning as provided in a different section of law, and shall, in addition, include the greater of gross income or value to the defendant of the victim's services or labor, or the value of the victim's labor as guaranteed under minimum wage and overtime laws. So you have to give him the greater of the amount of either minimum wage or the value of those services if it's a different kind of job. So if this were, enslavement of someone who provided more valuable services, then you'd look to prevailing market rates and you pay that. But this is a dishwasher, so minimum wage is probably the right amount, and still it's $272,000. The relevant law in turn defines full victim amount and losses to include any costs incurred or reasonably projected to be incurred in the future by the victim as a result of the offenses involving the victim, including medical expenses, attorney's fees, and lost income. And Fair Labor Standards Act guarantees a federal minimum wage of $7.25 an hour and overtime compensation at 1.5 times the employer rate for work over 40 hours per week. That 1.5 time for a non-exempt employee when you're making them work 100 hours a week is really going to add up. The relevant law also provides that an employer who fails to pay minimum wage and overtime compensation as required by law is liable for liquidated damages in the amount equal to unpaid minimum wages and overtime compensation. So, as may surprise no one, it is illegal to enslave someone, and it's also illegal to not pay them, right? Slavery is when you make someone do work they don't want to do. If you don't pay them, that's an additional bad, right? So you can't make someone work for you even if you pay them. That's not going to fly. But he didn't do either, right? He made them not work for him and he didn't pay him. So, he gets the damages for the pay that he didn't get because of all of his work in this cafeteria. Our analysis regarding restitution begins with the text. The relevant federal law mandates a court order restitution in the full amount of victims' losses resulting from the labor. As defined, full amount includes, as one option of measurement, the value of the victim's labor as guaranteed under minimum wage and overtime guarantees. This section references the entire Fair Labor Standards Act, not just the sections that were quoted by the district court, which addresses minimum wage and overtime compensation respectively. To be sure, the relevant law do fix the amount for compensating employees, but when an employer fails to comply with those provisions, the Fair Labor Standards Act adds to that compensation liquidated damages of an amount equal to unpaid wages and overtime compensation. So the way the federal district courts read this is you're only entitled to what you should have been paid. So we're going to give you the $272,000 that you should have been paid, in addition to putting this guy in jail for 10 years. Now, the Court of Appeals chides the district court because it says, look, you did read the section dealing with minimum pay and the section dealing with overtime pay, and you did calculate that properly. But there's an additional section, right? Because it's illegal to enslave someone and it's illegal not to pay them. So if you paid them, then you paid them, but that's also illegal for other reasons. But if you don't pay them, not only do you owe them the money you should have paid them, but you also owe them liquidated damages on top. This is meant to provide additional incentive that you pay someone for work. If you enslave someone and you don't pay them, you might have to pay them not only their salary, but you might also have to pay them some additional damages because you didn't pay them their salary, which kind of sounds fair, especially with the 5 years of the physical abuse and the hot metal tongs and the 100-hour work weeks and, the belts and, it's just, all that stuff. The Fair Labor Standards Act's liquidated damages requirement make perfect sense when considering that the goal is to provide full compensation to employees. Minimum wage and overtime compensation must be paid on a current basis as work is done, such that an employee receives the amount of compensation without delay. But when an employer fails to pay those amounts, the employee suffers loss, which includes the loss of the use of the money. So, right, not only did you not get the money, you didn't get the ability to spend the money, which is also a loss, right? You didn't get the benefit of that. So fully compensating the employee requires accounting for that loss. These losses could be compensated by interest, but the federal law compensates more fully for losses by providing a liquidated damages, which includes not only interest, but all other losses caused by the delay. So, yeah. So it's like, when you get paid now. If you get paid later, you didn't get paid now. And that was money you were entitled to now, not later. So, we could compensate you by interest and giving you present value for the money. But the federal law came up with a different solution. It came up with a different solution. It's like, how about times two? How about you give us all the money again as compensation for all that loss? Because you didn't pay them at the time. So break out your checkbook and write a check for about $600,000. Way to go. As well understood, liquidated damages are, by definition, compensation for a reasonable estimate of damages. And in the case of Fair Labor Standards Act, they compensate for employers' retention of workmen's pay, which may result in damages too obscure and difficult of proof for estimate other than by liquidated damages. Someone in chat asked the question, what about intentional infliction of emotional distress? Which is a very good question. So we are not in the context of a civil suit at all. We are in the context of a criminal conviction. And part of the federal law requires, as part of the criminal conviction, to give compensation in the amount of pay. So we're not even contemplating, any sort of civil remedies. So these are all remedies that the federal law guarantees as a result of a criminal conviction. So you're saying to yourself, what about intentional infliction of emotional distress? which is a very reasonable question. But the broader question you should be asking is, what about a civil suit? How about a claim of false imprisonment? How about a claim of battery for all the times that I was injured? How about a claim of intentional infliction of emotional distress? How about a claim of negligent infliction of emotional distress? How about other things that we haven't even dreamed of, right? So the federal law gives you money as a result of a criminal conviction. Does that bar your ability to sue for the other things that they did? No, it certainly doesn't. Does it prevent you from going after the J&J restaurant, who I'd like to remind you was the employer of this guy? No, it certainly doesn't. So if you're thinking to yourself, well, man, why can't he sue for other things? He hasn't sued for anything yet. The federal government just says, here's a check for $550,000. That has nothing to do with your remedies in state court. Go have fun there too. And with this conviction in place, should go a lot easier, so there's that. So yeah, that's why intentional infliction of emotional distress isn't being brought up. Because amazingly enough, we're not in the context of a civil law claim. This is criminal law. And the federal government says, yeah, you're entitled to money as a criminal penalty for all the bad. So hopefully that answers that question. Indeed, it would be inconsistent with the relevant laws requiring of providing restitution in the full amount of losses not to compensate a victim for losses incurred as a result of delay in paying regarding wages and overtime. In reaching the opposite conclusion, the district court reasoned the Fair Labor Standards Act liquidated damages are punitive and apply only in civil cases. Edwards joins in that argument, adding that reimbursing Jack for withheld minimum wage addresses all of Jack's losses caused but no more. But this argument fails to understand that liquidated damages are generally an amount determined to be a reasonable estimation of actual damages that might be difficult to or estimate to calculate, and that is their role in the Fair Labor Standards Act. So yeah, the Fair Labor Standards Act says, here's a pile of money we're going to give you. You might have remedies under state law too. Go have fun with that. At bottom, we conclude the value of victims' labor as guaranteed under the relevant minimum wage and overtime guarantees of the Fair Labor Standards Act includes the liquidated damages provided by the Fair Labor Standards Act. This fulfills the defendant's obligation to compensate the victim for full amount of losses which include the full value of the labor. These are full amount of losses related to the employment, not all the losses, right? So yeah. Accordingly, we vacate the district court's award of restitution and remand for recalculation. So the district court said no to the $272,000 times two. And the Court of Appeal says, how about yes? How about yes to $270,000 times two? So, go back and break out that calculator and do it times two. Try harder. Thus, that brings us to the end of the case of United States of America versus Bobby Paul Edwards. In this case, Mr. Edwards did it bad. He enslaved a mentally disabled person for 5 years, making them work every single day of the week without pay, beating them, abusing them physically and verbally, and burning them, and all kinds of nasty, nasty things. And Mr. Edwards got caught. And Mr. Edwards gets sentenced to 10 years in federal prison. And Mr. Edwards also gets fined $270,000 for back pay. And the district courts and the United States of America said, how about times two? And the district court said, no. And the Court of Appeal said, yes, because the relevant law says you have to compensate him. So the amount of liquidated damages is the amount meant to compensate you for the slavery. So you got that for the slavery, but you still have a whole bunch of things on top of that. False imprisonment, right? Battery, intentional infliction, negligent infliction. We can just dream up causes of action all day long. So somehow I don't feel this is necessarily the end of this rainbow, but at least for the minute, Mr. Edwards owes this guy about $600,000 for the slavery. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye. We make the algorithm happy over here on Uncivil Law. That's what we do. We are all about that algorithm. We love that algorithm life, yo. We want to make sure the algorithm is super, super happy. Super happy, all the happy. So that's why we talk about slavery.